To Sarah Jane.
Just in the context of conflict of interest and the director's duties generally, it's always nice to look at an example of where this has sheeted home. And a recent example that came out of the courts last year was down at UDI and Gillies. And this was a situation where the managing director had arranged with the chief financial officer for two payments to be transferred to him to pay for a boat. And the managing director did this because he felt that he was entitled to these payments to be made by the company as an advance on his bonus. But the managing director did not disclose this to the company, and it was about some $200,000. Subsequently, the company sought to terminate the managing director's employment, and this transaction came to light, and they used this transaction as a basis for terminating his employment for cause. And the managing director appealed and went to the New South Wales Court of Appeal. And what the Court of Appeal said, which is pertinent to some of the concepts that Paul's discussed, was that by taking those sums of money without disclosing it to the board, the managing director had, irrespective of his employment contract, had acted in breach of his director's duties. It goes back to those duties of disclosure, of good faith, improper purpose. And needless to say, he was unsuccessful in having his contract, receiving a payment of compensation for wrongful dismissal. You'll notice that on our agenda we also wanted to provide an update on some developments that are happening in the area of governance and directors' duties, and no more pertinent is the area in relation to social media. And a couple of instances here that you'll see on your slides. One of them is a case of Sea Folly and Madden. Sea Folly, as those of you may be aware, is a swimwear company, and Madden was the owner of a small swimwear company who thought that Sea Folly was imitating her designs. So she posted on her website the comment, "The most sincere form of flattery," and then had pictures of the designs she felt that Sea Folly were imitating. Sea Folly were not happy about this because they hadn't imitated her designs, and they sued her successfully, claiming misleading and deceptive conduct. What was interesting here, though, is that Madden thought that she was putting these on her personal website and that it was just a statement of opinion. The federal court did not agree and said that by putting this on the website, she was making a reckless and public expression that could be subject to misleading conduct, as was found against her. What's interesting there is companies, even very small companies, have to be very conscious about what they're putting on their websites. Interestingly, as you'll see on your slide there, the Advertising Standards Bureau has recently said that it will be looking at companies' Facebook sites and applying the same standards that it would apply under the provisions of the Advertising Code. The issue in relation to Facebook sites is also quite pertinent when it comes to employees. And in the instance of Linfox and Stutzel, Mr. Stutzel was an employee of the Linfox group, and he posted some very perhaps disparaging comments about his manager on his personal Facebook site, and was dismissed by Linfox as a result. Mr. Stutzel took proceedings against seeking reinstatement and the full bench of Fair Work Australia supported his claim. And they supported his claim on a couple of fronts. One was he was an elderly gentleman and he claimed he didn't understand the implications of putting these comments on Facebook. Secondly, though, and perhaps more pertinent, and particularly to those of us who are directors on companies, is that there was no social media policy within Linfox advising its employees of the inappropriateness of such conduct. So as a result, Mr. Stutzel was successful in pleading that he was ignorant and getting his job back at Linfox. Some of you may be aware, because there's been quite a lot of media and commentary at the moment in relation to changes to the Australian privacy principles. Without going into them in too much detail, it is worth noting though that they have a much more far reach than their predecessors, which were the national privacy principles. Significantly, any business that has a turnover of more than $3 million will now be subject to the Australian privacy principles. And that's a cause close to my heart as a former director of an independent private school, and some of you may be involved in the private school sector. Significantly, some of the requirements which you have up on your screen, but one of the more pertinent ones is to ensure that there is a privacy policy and that is disclosed to those. So in the school context, that you'll be making your privacy policy disclosed to parents and students alike. And some of you may already have noticed, I know I have noticed, that some organisations are now asking for consent to be able to disclose information, and in the past they had not sought that consent. Interestingly, I'm a shareholder of Westpac, and I received something in the mail only yesterday saying, do I consent for my details to receive some of their direct marketing material? That's in response to these new privacy principles, where you must obtain somebody's consent before you provide them with direct marketing material. There are some exceptions, but generally you need to get their consent. And also, coming back to the issue in relation to websites, which is worth noting, is that it's important where you're using websites to distribute information that you provide an option for people to opt out, so they can say they no longer want to subscribe to your services or receive your material. The big stick at the end of this is that the Australian Privacy Commissioner has a lot more powers, and of course there's a maximum penalty, as you can see on your screen, of $1.7 million, which could be quite painful. I just want to now move on to foreshadowing some of the things that are happening in the public company space. And while some of you may not be involved in the public company space, I always find it intuitive to look at that area as an indication of what could happen and flow down in the non-public company space. Because what we've seen over the last 4 or 5 years have been advancements on corporate governance issues that apply to ASX listed companies that are starting to filter through even to the not-for-profit sector. So in this context, there were some changes that were made to the Australian Stock Exchange corporate governance principles in March this year. Some of the more interesting changes was the introduction of a requirement that boards undertake appropriate checks before they appoint directors. So they undertake appropriate police checks, reference checks, etc. That directors